if he designates something as personal, he doesn't have to tell anyone what he's doing with them. He can tear them up. The court notes that at the outset that there is broad language in a decision called Armstrong 1, which is a District of Columbia Circuit decision, meaning it was an appellate decision that governs this court decision that we're talking about here, stating that the PRA, it's a Presidential Records Act, accords the president virtually complete control, quote, virtually complete control over his records during his time in office. In particular, the court stated the president enjoys unconstrained authority to make decisions regarding the disposal of documents. Quote, although the president must notify the archivist before disposing of records, neither the archivist nor Congress has the authority to veto the president's disposal decision. And I would go further. If he designates something as personal, he doesn't have to tell anyone what he's doing with them. He can tear them up. But once the records is designated as presidential, that's when this restriction about disposal occurs. Since the president is completely entrusted, again, this is the court decision here, completely entrusted with the management and even the disposal of presidential records during his term in office, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. That means storing them in a storage room in the basement of Mar-a-Lago. Don't it? Of course it does. And then, of course, the issue is who gets to second guess the president's determinations. Now, this court is suggesting the courts really can't. In fact, she writes, the court has serious doubts about whether the former president's retention of the audio tapes as personal is a matter that is subject to judicial review. Do you think Judge Reinhart was told that the district court judge that handled a specific case related to a dispute about the nature of records a former president had, that a court found that they had serious doubts as to whether that decision was subject to judicial review? I doubt it. And again, the court further finds the PRA does not confer any mandatory, again, or even discretionary authority on the archivist to classify records. They don't have any business doing it. Under the statute, this responsibility is left solely to the president. While the plaintiffs cast this lawsuit as a challenge to a decision by the National Archives, the Presidential Records Act makes it clear that this is not a decision the archivist can make, and that in this particular case, it is not a decision the archivist did make because President Clinton's term ended in 2000 and the tapes were not provided to the archives at the time. It's exactly the same issue here, isn't it? Of course it is. Another statement by the court. The archivist has no statutory powers related to either the reclassification of records or the retrieval of improperly classified records. I mean, this is pretty damning stuff, isn't it? I think it is. And this is why I've been so insistent about it, and this is why the left has been so angry with me and Judicial Watch for highlighting this beginning in the first part of the year, because I've been talking about this, I've been tweeting it out, and at one point the leftist fact checkers, who are activists to try to destroy and censor and suppress information and opinions they don't like, they called out all these other experts who pretended that what I was saying was bunk, and it wasn't bunk. It's completely accurate. It's based on our significant experience litigating Presidential Records Act, federal records issues over the course of 30 years nearly. Judicial Watch is the nation's, I would submit, leading expert on this topic. And this is what I love. And so the court was making fun of us. I say maybe I'm a little more sensitive than I should be looking at this decision. But she was like saying, well, what is it you want me to tell the archives to do? Raid his home? I don't think even we contemplated that. Maybe if I were arguing the case, I would have said, yeah, raid his home, but our lawyers are more careful than that. Defendant considers this, this is again, the government of the United States considers what we were asking them to do to be an extraordinary request that is unfounded, contrary to the Presidential Records Act's express terms, and contrary to traditional principles of administrative law. And she said, "What, you've asked me to order them to go get them." She quotes herself from the transcript here. And our counsel at the time, and he's still with us, Michael Bekesha, he said, yeah, to the extent we asked the court to require them to assume custody and control of the tapes. I mean, it sounds awful that they think we're asking for this court to bang down President Clinton's door and seize these audio tapes. Archives could make a phone call. They could write a letter. There's nothing in the records stating that President Clinton wouldn't just give them the records. We're not specifically saying they have to go seize. And she said to us in response to Michael's good faith offer there, you know, there's ways of trying, at least beginning to get the records. Plaintiff's indulgence in wishful thinking in order to minimize the ramifications of its own lawsuit underscores the lack of redressability in this case. So she's telling us, look, there's nothing you can do about it. There's nothing I can do about it. The law doesn't give the archives the ability to do anything about it. And because the law is the governing statute here, it unlikely gives anyone else the ability to do anything about it. One option is they can call President Clinton and ask. Our lawyer said, okay. He says no. Now what, the court says? They write a nice letter, which is exactly what they were doing with Trump, and Trump was being accommodating. And yet they raided his house anyway. Something that the lawyers here for the Justice Department never contemplated. The court ruled out, practically speaking, and was contrary to virtually every understanding of the Presidential Act and the deference given to a president in terms of what he's able to do with his own darn records. Case closed. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.